Mkhwebane appears to be on a war path with the committee. She wants it to put its proceedings on ice pending the finalization of her legal funding. This after the Public Protector's Office stopped her legal funding. Mkhwebane also claims the evidence leader's participation in the proceedings in the absence of her legal representatives is unlawful, and that this was an attempt to do damage control following her testimony on the CR17 and SARS unit.
Advocate Mkhwebane, I see you have raised your hand. I'm going to hear you out, but I just want to explain this is a committee meeting. And people who participate in it are members only. So I wouldn't want to entertain any other person except the members. It's a committee meeting. So I just want to indicate that I see you've raised your hand. I cannot take it. You'll have to find another way if you need to communicate with the chair. It is a committee meeting. I'm only allowing members to participate in the meeting.
Not members, Chairperson. I've written you an agent letter.
I will look at that letter. Thank you.
And it's not for you only. It's for the committee. And evidence leaders are not members.
I did not give you platform. Just mute here. You're not going to repeat that. Okay. This is a meeting of the committee.
I've sent you a letter.
You are not a member unless you are.
But the evidence leaders are not members.
Just mute her. Just mute her. It's a committee meeting. You're completely out of order. And I'm not going to take that attitude from you.
Meanwhile, the evidence leaders have been analyzing various judgments that seem to dispute some of Mkhwebane's evidence, including on the Constitutional Court findings, setting aside her CR17 report.
The Public Protector makes sweeping findings which do not show how the President exposed himself to a situation involving the risk of a conflict between his official duties and private interests. It is difficult to appreciate how the breach of this prohibition was established without identifying the President's private business and his official responsibilities, in respect of which he had exposed himself to a risk of conflict.
But Mkhwebane has taken issue with the continued leading of evidence in the absence of her legal team.
I am here. I am alone. I don't have my legal representation. And Chairperson, as this committee, you are obliged to act according to what the Constitutional Court has said, firstly. Secondly, Chairperson, you've got directives.
But Janji's decision to give the evidence leaders the green light to talk about Mkhwebane's evidence through strong objection from other committee members.
You can't say she must continue whilst we are questioning her presence and the presentation under the present circumstances. Don't bully us.
You cannot continue in the absence of a legal representation. So, Chair, this thing is illegal that you're doing. Let's just stop here. Advocate Bao must pack your bags and go. This meeting must be adjourned.
But ANC members of the committee supported Janji's ruling.
From my side, I'm very comfortable with what is currently happening, because what the evidence leaders are currently doing, they are empowering us.
While other MPs want the committee to simply exonerate Mkhwebane to save time and resources.
Chair, this has been a very expensive motion for the country. We cannot allow matters to drag on until the term of office of the Public Protector ends.
Mkhwebane protested strongly as well.
You can't say it's a public.
No, you can't do that.
We can get it, but why are they participating? No, Chairperson.
I did not give you a platform.
No, Chairperson, you can't treat me like that.
Mkhwebane also laid into the evidence leaders.
This is illegal and unlawful and unethical, and possibly I'll exercise my right as well to lodge a complaint against the evidence leaders to the Legal Practice Council, because you cannot behave like this as evidence leaders.
But this did not deter the evidence leaders from tearing into her evidence.
Clearly, the public protector had no foundation in fact and in law to arrive at a finding that the president had involved himself in illegal activities sufficient to invoke a suspicion of money laundering. In addition, the public protector based the finding on legislation that had nothing to do with the offence of money laundering. We had covered that. The conclusion is inescapable that in dealing with this issue, the public protector completely failed to properly analyze and understand the facts and evidence at her disposal. She also showed a complete lack of basic knowledge of the law and its application.
Bawa also pointed out that President Cyril Ramaphosa was not given a chance to respond on the remedial action.
When an individual is implicated during the course of an investigation, the public protector is obliged to afford such person an opportunity to respond to the implicating evidence. If the implication may be detrimental to that person, or if the finding adverse to him or her is anticipated.
The committee will resume next Tuesday. Bulelani Phillip, SABC News, Parliament.